Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
You are listening to the Roberta Glass True Crime Report, putting the true back in true crime. From New York City, Roberta Glass is now on the record.
Still in the afterglow, or at least I am, of this glorious day we had in court yesterday, where Hank Brennan exposed Karen Reed's criminal, lying defense lawyers for the frauds they are, and exposed them for perpetuating a fraud on the court. And so I think, just to give you a heads up, I will talk about Aiden Turtle Boy Carney's interview with this juror. I just moved it till Saturday. I'm going to be going over a lot of what has come out, the aftershocks of this ARCA revelation. So what happened yesterday is that Hank Brennan, so Alan Jackson, who presented this witness as being a totally neutral witness, and because he was in the federal part of the investigation, that they couldn't talk to this witness. So let's start at the beginning. Actually, hold on. I'm going way too fast. That he couldn't talk to them, and that they couldn't really give over any discovery to the Commonwealth. And this has been a pattern, as I proved yesterday, with the defense. So what they do is they say, look, I just met this witness, or it was a federal witness. I couldn't vet them. I don't have any discovery. They haven't, remember, Marie Russell didn't write a report. And then they have to get some kind of remedy for this. So they had to be voir dired, these witnesses. So the ARCA witnesses and Marie Russell all had to be voir dired. And this is their trick to avoid discovery in the Karen Reed case. Just say we just met them. We're not allowed to talk to them. So let me just show you very quickly how this all started before I go into the actual video of the hearing. So this is from Julie Carpenter's Twitter.
We've provided everything that we know. We've mentioned to this court at sidebar, these experts did not arise from us.
I understand that.
So because people have a short attention span, she wisely sped up. So this is not at normal speed. This is David Yannetti at the time explaining to Judge Cannoni why they could not comply with Adam Lally and the Commonwealth's request for discovery from ARCA. Take a listen.
experts were hired by the federal government, and they provided a report to us pursuant to the TUI request, and it was specifically outlined that and ruled that they could not prep with us for trial.
So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here
That's essentially it. We've spoken to them only for the purposes of coordination of their testimony and their background. That's it. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have.
See, I don't see that as being, the report, I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify to.
Well,
and
So Yanetti's there saying, well, we handed over the report. And Judge Cannoni's saying, I don't see this report as particularly detailed. Is this a little loud? Let me turn this down a little bit.
you have not complied with your Rule 14 obligations.
We can't, Your Honor. We can't.
So you can't, but you haven't. So I am left with you haven't complied. So we need to get everybody here for voir dire. They can testify in voir dire, right?
Yes.
We need to do that well in advance of their
Okay,
testimony.
that's fine, Your Honor.
All right.
Yep.
And now
He's like, great. Just like we planned. Going exactly as planned. Sorry, we can't. We've never talked to them. Finds out that they paid them a retainer of $23,900. That they choreographed, scripted the questions and answers between the ARCA witnesses. And watching the whack jobs gave me a great reminder of what went on in court, and a clip I'll play. And thank you, watching the whack jobs, for this. I made a tweet about it, but I'll play it in a second. But let's finish this out.
now tell me about this ER doc.
Yes, sir.
So tell me about the ER doctor. Played that yesterday. I just met her. So I'm questioning, can't give any discovery. She's got no report. I don't even know what she's going to say. That's how they played it off. Meanwhile, Hank Brennan shows emails. Hi, Alan. Here's what we're going to get. Here's what we're asking to get paid. If you don't want me to say this, I don't have to. Especially if you don't want me to mention that most car accidents happen at night, I don't have to. I can keep it all secret because I'm on your side. I mean, it's the definition of a hired gun. So all we've been hearing from the Free Karen Reed side is, what about ARCA? What about ARCA? They weren't hired by the defense. They weren't paid for it by the defense. What about ARCA? What about ARCA? And I'll get to Aiden Turtleboy Carney's response on X today in a few, but before I do, let me just pull up the video of the ARCA, the actual ARCA testimony.
Qualified as other person testifies as an expert in the area of accident reconstruction. Is that right?
Yes, sir.
You were not hired by the defense in this case, correct?
That is correct.
At the time you did your expert review, Dr. Wolf, and your consultation.
So listen to this. So this is a little show for the jury to show how independent he is. But listen to Alan Jackson's language. It's very careful. You've never met me. Well, they might not have met, but they've communicated. When you wrote this report, you didn't know anything about me or the case. This may all be untrue too. We don't know, but it's carefully crafted to avoid the things that you can prove, except for the part where he says, we're not paying you. We'll get to that. But all this, you could say, well, I didn't say we hadn't met, but we communicated. I don't think he's going to have a good time. So he could be thrown off the case. Judge Cannoni has given him permission to practice in Massachusetts. That could be revoked. He could lose his law license, which I think he should. He won't. And what I'd like to know is how long has Alan Jackson been using this technique? I'd love to talk to some prosecutors who've gone up against Alan Jackson and had discovery issues with Alan Jackson so he could sandbag the prosecution as surprise witnesses. And I'm vaguely recalling also some interview with Alan Jackson where he says we don't want to give up or maybe it was a comment he made in court about using the element of surprise. Does anyone else remember that? I have to search my memory a little bit more deeply.
You and I had never met.
That's correct.
You did not know who I was.
I did not.
You'd never met Miss Little.
No.
Mr. Unetti.
No.
Matter of fact, you'd never heard of this case.
That's correct.
You were hired by another agency not connected in any way to the defense. Is that right?
Correct.
And not connected in any way to the Commonwealth. Is that right?
Correct.
So your analysis and your conclusions and your opinions are completely independent of the defense and the Commonwealth in this case. Is that right?
Objection.
Sustained. Mr. Jackson, you can ask it differently.
Boy, don't I wish he had answered that. Because that is just straight up fraud. Unfortunately, I mean, that's straight up fraud right there. So that's the definition of a fraud upon the court. You're not playing for the defense or the prosecution. You don't have a side. You're the most neutral, unbiased witness. You're just going by the science. That's what these free Karen readers said, the science, the science, the science. They're awfully quiet now because there isn't much to say. They're going to talk about Hank Brennan and how he misspoke and corrected himself. But that's not anywhere near what this is. You cannot have a paid hired gun on the stand and not give that information over to the prosecution and what they're going to say. Because had the prosecution done this, the prosecutor would have lost his job for sure. But defense attorneys, my feeling is Judge Cannone may throw Alan Jackson off the case because she's been embarrassed. And as I mentioned yesterday, she's been exposed by this as well. As a defense lawyer herself, she could not have missed that there's something unusual, odd, or even that this is a common trick of defense lawyers to hide discovery. And that voir dire where the prosecutor doesn't get to cross-examine the witness is no substitute for handing over discovery and knowing that ARC is getting paid $23,000 and that they're scripting, the defense is scripting their testimony. This is not the first time I think this has happened. Marie Russell's testimony has changed. Her opinions have changed, and the language has changed that she uses from when she testified in the first trial to her report that she was helped, meaning I think Robert Alessi, Karen Reed's new pro bono lawyer, wrote that report. That's my opinion. Ditto, there were 2 reports, and I think one was a draft and one was, I would think, 2 reports handed in for Richard Green. How did that happen? Because Robert Alessi was writing them. They weren't from Green. They were from Robert Alessi. So they've been the puppeteer with their, like a ventriloquist. They've been testifying for the defense as expert witnesses in their own trial, these lawyers. And these are just ventriloquist dummies, essentially, which would be somewhat acceptable. It's not acceptable for them to write the reports or craft their opinions. But had they handed over the information of their real connections to the defense? Hey, Rena, nice to see you. Remember OJ opening statements to the jury? Wait until the end. Oh, Alan Jackson. It was David Unetti's opening statement you're talking about. Wait until the end. That itself says that Alan Jackson knew what ARCA is going to say. That was, yeah. I mean, they all know how the trial's going to go in their game plan. Yeah, David Unetti gave the opening. Lazy Susan. How do you think Hank Brennan feels about having groupies? I know. You're not alone, Lazy Susan. A lot of people have a real crush on Hank Brennan. And what exactly constitutes stalking? Besides, I'm pretty sure I'm in love with Brennan. You're not alone. You can make Brennan's Broads your own Facebook group. I'll join. I'll join Lazy Susan. He is really, he's not fooling around. He means business. And he's just very on point with the language that he used, talking about the witness harassment, the relationship between Aiden Carney and Karen Reed being a symbiotic one. He's not fooling around. And finally, I hope he's really determined to get justice for John O'Keefe's family. Because these, like I've said, these innocence fraud campaigns are very powerful. I was watching Julie Grant show, and one of her lawyer guests was saying, well, Karen Reed's been appealing to the wrong court. And I was like, no, she knows exactly what she's doing. She shouldn't be appealing to the court of public opinion. She should be appealing to the court. That's the one that matters. Not when you can, not when you, it should ideally work that way, but not when you have a powerful, well-moneyed innocence fraud campaign that the media all jumps on. It's worked very well. Had she not had that campaign, does anyone think that she would have gotten a hung jury last time with the evidence presented? I don't. Let me know what you think. Here's more of Alan Jackson's tap dance.
When you did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct?
Correct.
That report is contained.
And not only is Alan Jackson lying to the court, let's not forget that Daniel Wolf, the ARCA expert who you are hearing, not seeing so much in this footage, is perjuring himself. Will he face perjury charges? Very seldom come forward perjury charges.
In a multi-page document that was submitted following your analysis and your opinions and conclusions, right?
Correct.
The defense didn't have anything to do with that, correct?
Correct.
You had never met us, didn't know who we were when you did this.
Correct.
You'd never met Mr. Lally, didn't know who he was when you did this.
Correct.
So your analysis, opinions, testing, and
your analysis opinions have nothing to do with us. Meanwhile, there's the communication. Do you not want me to say this? Should I say this? Is this helpful to you? That's not an independent witness.
conclusions were requested by a completely separate agency.
That is correct.
All right. Goes without saying, but I'm gonna ask it anyway. You haven't been paid by the defense? You
have not paid us anything, no.
It goes without saying. It's so ridiculous. I don't even want to ask this question. But you're not being paid, are you? Oh, no. He goes, we have not been paid. Did you hear his answer? We have not been paid. Does that mean that they didn't pay him yet? You see how the language, these lawyers are wordsmiths? You haven't been paid by the defense. No, we haven't been paid yet. We've been retained, but we haven't got that check yet. Maybe. I would think that they wouldn't testify if they hadn't gotten paid, unless they're foolish. Hey, watching the whack jobs. Yeah, this is a great find. Thank you.
And you don't work for us.
That's correct.
As a matter of fact, I've never asked you specific questions about your testing before today.
That is correct.
Your work product, the report that you provided, was provided both to the defense as well as the Commonwealth. Is that right?
That's my understanding, yes.
And you were equally available to...
Your report was provided to the defense and the Commonwealth. The report that the judge is like, I don't think it's all that detailed. This report that's not very helpful was provided to both of us. And here he's saying that he could have met with both of them. Is that what he's saying here? Hold on.
Both sides.
In terms of them reaching out?
Correct.
Yes.
And I...
Wait. How can he say we can make himself available to both sides when they said the reason that they couldn't talk to him is because he was a federal witness and they couldn't talk and they couldn't be available? But he hasn't met with either side?
Called you ultimately after receiving your report, asked if you join us and testify, correct?
That is correct.
All right.
Oh, asked us if you would join us and testify. I recruited you after I read your report. The state could have brought you up here, but they didn't. Because they didn't like your opinions. That's why they didn't use you. This is just absolute. How do you say that this is not a fraud upon the court? This is the definition of a fraud upon the court. And if Judge Canoni does what she's always done, let these things pass. I just want to know how long Alan Jackson's been using this technique. Is this Alan Jackson's technique, or is this David Yanetti's technique and Alan Jackson's just using it, or both? To my eye, just having studied a lot of innocence fraud, this is a very unusual case of innocence fraud campaign. Usually they're post-litigation cases, meaning the person has already been convicted, which is why so many of the people I talk about are very guilty because they've been convicted. It's gone through appeals courts. But here, it's this pretrial. But to my eye, he looks like the slightly larger fraudster than Yannetti. He's being called the face of the defense team. And if he gets thrown off, this will delay the trial. That's another thing. I doubt we will start April 1st if he's thrown off. But again, I'm not confident that Canoni's going to throw him off. Again, she should have known. I think it's impossible for her not to know that they were committing a fraud, and she let it slide for whatever reason. And you can see she gets very embarrassed and upset, and she's exposed by this. So one half of me thinks she'll do what she's always done, which is give them kind of sort of like a slap on the wrist and let it slide. But another part of me, on the other hand, thinks that she might throw Alan Jackson off this case. Really what she should do is I think he should be disbarred for this. I don't want a lawyer like this practicing. If I'm Our court system is based on fairness. It's not based on who gets more money and who can stack the deck in their favor. I know money is always an advantage in every area of our society. But this is unreal.
Were you and your team asked to undertake a review for purposes of accident reconstruction of the case that's now pending before the court?
Yes, sir.
Was your team asked to do this by the agency that ultimately retained you, not us?
That's correct.
Who at ARCA was assigned to the team who would ultimately undertake this job of accident reconstruction?
So great find. I mean, I just think this is the tip of the iceberg of the fraud that they've committed on the court. I think it was done with Marie Russell, Green, Lucky Loughran. I think they totally scripted and drilled. His testimony seemed completely rehearsed. Lazy Susan, I wonder if there was more said during the recess. That's interesting. Was the recess, I thought the lawyers, were they in chambers with the judge? I didn't think so. I thought the judge just went back to her chambers. You mean at the defense table? So let's look at the actual event one more time, shall we? Hold on one second. So let me go through all of this. It's right after here.
Any follow-up, Ms. Little?
No, thank you, Your Honor.
All right, so I'll take that under advisement. Do you have that Rule 17 paper number?
Your Honor, we don't have the paper number.
Sure.
So does everybody love the new opening? I had fun making that. Had to freshen it up. I feel like we've turned a new chapter in the Karen Reed case, and I felt like we needed a fresh opening for the show. It's a variation on an old theme.
Your Honor, my purpose is not to deprive the defense of an expert or deprive the defense of an ARCA expert in this case. But there has to be a minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other in that expert witness.
Collaboration is a great way to put it. Was there collaboration between the expert witness and the defense? And that's I see collaboration with every defense witness too. And then hiding it, right? Hiding their relationship. Do you remember when Marie Russell slipped and said, Robert Alessi helped me with my... Did anyone help you? Oh, Mr. Alessi did. Well, he just told me where to put things on the forms. She's a medical doctor and she doesn't know how to put together a report. Give me a break. He wrote it. And how does Richard Green have 2 reports, both mistakenly handed into the court?
Witness that they don't know about and can't ask about. That there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination. It's not the ARCA witnesses that I have the issue with. It's the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations, for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCA, and it was represented these experts were hired by the federal government, and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial. And so Your Honor said, so I am to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And the answer...
Right. You're going to put someone you don't know what they're going to say? Everything that a lawyer is taught to do is about control. You never ask a question you don't know the answer to. Something I talked about with in my interviews with Deputy DA John Lewin. He says lawyers are taught to only ask questions they know the answer to. And he hates that technique. But so you're not caught out in surprise, so your witness doesn't say something harmful to your case. Everything is carefully crafted with the language and what you're going to say, to know what they're going to say and to be able to present your case in the best way. And Judge Cannoni, when she was sold that line, her response was to say, "Oh, that's okay. All right, I'm going to buy your bologna. I'll buy a little bit of your bologna. I'll take a bologna sandwich from you, Yannetti and Alan Jackson. And we'll just have a voir dire." Oh, terrible punishment. Not a voir dire where I get to ask a few questions that probably arranged beforehand and my client gets to answer. Like born and raised in the briar patch, the briar rabbit all over again, right? Not the voir dire, Judge Cannoni.
That's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And you're...
Hey, Janet Gardner, you're not alone in thinking this. I've gotten a lot of comments like this. Did the defense really turn over the emails? They have to. They have to. They just want to destroy their case because they know they can't create phony emails, although I'm sure some lawyer has. These lawyers think a lot like criminals. They had to show something. They had to. Hank Brennan was going after this discovery vigorously. They had to hand over something. And so so they have either get caught on this. I don't know. It might have been better to just say, I don't know what. They had to. They were pushed. They tried to avoid it for months. He's been asking for months for this, Janet. They had no choice. And as a lawyer, you have to hand over everything you have. And, you know, Alan Jackson's probably going to do some Jedi mind power on the court next Tuesday. I'll be covering it. Like, I don't know. I wouldn't, I'm so honest. I even handed over something that, you know, could get me in trouble. I don't know. But I wouldn't hand over something that would get me in trouble. I don't know what he's going to say. If I thought there was anything wrong with the way I presented it. But roll the tape. Let me cross-examine Alan Jackson.
Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So where in the transcript is this?
On page 2812 and 2813 of June 10, 2024.
This is another thing. I was listening to so much on this incident today. I'm not sure where I heard this, but the lawyers were suggesting that Judge Cannoni could not have forgotten this moment in court when she asked David Yannetti, hey, you're going to put up 3 witnesses you never talked to? And so to answer my question from yesterday, and by the way, I want to make a correction. You know, I do make mistakes and I do try to correct them. I called Daniel Wolf Richard Wolf yesterday. So his first name is Daniel. That was my mistake. I'd just like to correct it for the record. And if you ever hear, please feel free to correct. Try to make this show as accurate as I can. I do make mistakes. I am human. But if I often put my corrections in the show notes, you know, like, or the description, episode description is a better way to put it.
Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day.
A dark road that never sees the light of day. I'm going to take a quick break. This is a good place to stop. But up next, Hank Brennan on Getting Duped. Would have been a good title for this episode. I'll use it one day. When we get back, don't go anywhere. I'll be right back in 1 minute. See you on the other side of the break.
Glass of wine. Roberta will be back in no time. This podcast is listener supported, so smash that like button and subscribe or become a patron for exclusive content if you are so inclined. Have something to say? Shoot Roberta a super chat. She will do her best to read it on air without delay. Now Roberta's back and ready to put the true back in true crime. Here's Roberta.
Okay, now back to Lazy Susan's. Crush Hank Brennan on Getting Duped.
So I filed the TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive, just when I read the materials, and Attorney McLaughlin actually identified them. they didn't respond to our request, so Attorney McLaughlin wrote back. And then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024, is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and return to you forthwith, along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment. They relied on a reciprocal discovery order of this court for that information.
Right. And it's the judge's job to make sure that those orders, meaning they asked for discovery. We've given you what we have when we get it. And last time, the defense's answer was like, well, we're getting things very late, too. Late is different than never. I don't remember any voir dires having to be done on the state's witnesses. Am I forgetting? Only on the defense witnesses. On the defense witnesses. Isn't that interesting? Only people had trouble with discovery were the defense. So in the typical Karen Reed style, and Alessi sitting there just anchors me. He's like this nerdy guy. He's a former pharmacist. He does all sorts of different kinds of law, civil lawyer. And he wants to get into the big time with the cool kids and be on a high profile case. So he's doing this for free. But he's never been fully accepted. He's just sort of used like the nerdy kid for his homework. And what a disgusting thing to do for your own ambition. Imagine having to pass Peggy O'Keefe and the Keefe family every day in court. And you're working for their son's killer just to further your own ambitions and interests and create a little excitement in your life and get a little fame for yourself. Talk about a deal with the devil.
Response, hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward. Now, it's not the opinion that troubles me. It's the relationship, and the Commonwealth should have an even playing field. Saturday, June 20th.
It's not like a court appointed a defense lawyer. He's doing this because he thinks defending a killer is fun. It's not his duty. It's not his job. He's volunteering. I'm totally disgusted by him. And ARCA, too. Imagine going up and giving this testimony. Oh, no, we haven't been paid. We're totally independent. We're just trying to help get a killer off. Because that's the way that's her side, my wife's side. She's a free Karen reader. And who knows? I mean, the federal investigation is where I see a lot of people pointing to corruption, when the biggest corruption of our courts which much more of us will be affected by it than the federal government, is going on right here. And I've been talking about these lying lawyers, fraudulent lawyers since day one. If they were really such a dream team, they wouldn't have to break the law. They wouldn't have to go beyond the bounds of the law to win a case. They could do it in court.
Second, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications. Also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary.
See, I thought the voir dire was fantastic. That little show and dance we did for the judge, that was fantastic, Alan. Feel free to make any changes towards my testimony. That's what he's saying. I'll change my testimony however you want me to. And then I'll get up on the stand and swear under oath that I'm an impartial witness who's getting no money from the defense. Is anybody else disgusted?
Now, this isn't information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, 2 requests, and an insistent, the best I can, to get as much information as I can. We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury, the privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took no side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody. So we see in the margins in the notes, this fair-minded, objective witness says, so not being able to inspect the vehicle is something that's not uncommon in your line of work, and he writes absolutely not, and then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
It's not dated.
I need to show the jury that it doesn't matter. Whether I actually looked at the vehicle. That's what we really have to highlight. Thanks, Lisa, so much for your super sticker. That part just kills me. See, I'm going to help you win your case. We have to convince the jury that it doesn't matter. And I do have a couple clips to show you from the juror interview just about Arca and why I find him an unreliable narrator of what went on. And I'll explain that a little bit more Saturday. What went on in the jury room. I thought his comments on Arca were compelling.
It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of Arca, or not. I'm not saying they're not qualified witnesses, but it certainly shows.
You know what I am saying, though? I do say Marie Russell. That's what he was saying about Marie Russell. She's unqualified. And Richard Green, wholly unqualified. Judge Canoni's response, let them all in. Let them all in. Let Richard Green testify on something that the Cellbrite software had to rewrite so as to not have their users make the same Richard Green mistake. In conclusion, because it's so wrong. I don't know how much wrong. It's not even. Don't even get me started on Richard Green. He's not saying that their conclusions are wrong. He's saying this bias, this collusion with the defense and what was supposed to be an unbiased, independent expert witness is not so. And that's not how it was presented to the court. It's a biggie. Every lawyer will tell you that this is a biggie. In fact, as I'm doing this episode, I just got a text message from David McKenzie, who was a criminal defense lawyer. He's been practicing for years and years. Big name in Oklahoma. And he just sent me, and I talked to him about this case. He just sent me an article just about this. He couldn't believe it because lawyers can't believe it. This is such a no-no. It's so fraudulent. It's so sleazy. And I was showing David McKenzie, you can go back to my interview with him. I think it's called How to Argue Your Case in Court, Not in the Court of Public Opinion. That episode, go back if you haven't seen it. I was showing him Alan Jackson auctioning himself off for dinner with him and his killer client to raise money. And he's like, that is really distasteful. Not something I would do in a legal auction. I mean, come on. In my opinion, not on the up and up. I don't believe you can have a raffle in that way. That's just my belief.
Some bias. I've turned over a lot less in this case than this. Another comment. Would it be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians.
So this is like from their script. This is from their fake script. When he's presenting it to the jury that they've never talked, never met before, but one juror didn't buy it. I'm going to play it in a second. Didn't buy them as unbiased witnesses.
Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh. Don't tell them.
Right. All this was done in secret. You've never met me before. We've never talked before. You don't even know the name Alan Jackson. Hey, I won't say this. Hey, Alan, I won't say this. Right? Just pretend let's pretend we've never met and you're not getting paid. Okay. Love to know how this all went down. This all goes into the federal investigation started by Karen Reed's connections into all the officers who got her. See, everyone who knows Karen Reed's guilt must be punished. This is how innocence fraud campaigns work. Turn everything on its head. The good guys are now the bad guys. The bad guys are the good guys, are the victims. I mean, so it's really all about the bad police, not the bad Karen Reed, and the bad witnesses. Anybody who knows and has the knowledge of Karen Reed's guilt, get out the pitchforks, get out the torches. Let's go after him. That's how innocence fraud campaigns work. And they love to target victims' families and re-victimize them.
Have you qualified as an expert in court before? Yes. I realize my testimony, I said it 20 times when you asked how many I've been qualified. I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up. And then a bill from ARCA to the defense for $23,925. That's not trample. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. And sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation. And
His language is so awesome, isn't it? Use ghosts. He could have been a writer, you know? I mean, just these, and and it was Judge Cannoni's job to keep the courtroom fair, but instead she treated Adam Lally like dirt, walked all over him, brushed away his concerns, and we're just lucky she didn't get Karen Reed didn't get an acquittal with how hard she made it for Adam Lally last time around. You have 3 witnesses that all need to be voir dire. How often do you think that happens with Judge Cannoni? She couldn't suss out a fraud? Because I remember when that interaction happened between David Yannetti and Judge Cannoni, and we were all getting revved up thinking, oh, well, now there's going to finally be some consequences. They've already lied to the court in their filings by leaking information to Aidan Carney and then saying it's been reported as their own leaks, which came from Karen Reed's imagination. And again, nothing happened, a voir dire, and everything's coming in. I mean, it was, Marie Russell performed terribly. It's all coming in. So all your effort, prosecution, Commonwealth, it's in vain.
this person.
And I think it was a terrible ruling to let Marie Russell and Richard Green testify this time too. Terrible ruling, especially on Richard Green. Marie Russell, I think, is an awful ruling too, but Richard Green is like, well, it's the worst ruling I've ever seen by a judge.
And then this happens. I don't care if the witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCA.
All right, I'm going to take a recess.
So what people are missing about this is it's Judge Cannoni's job to keep the courtroom fair, to watch out for things like this. And all this went on under her nose. And she let the defense do one fraudulent thing after the next with little to no punishment. What punishment is a voir dire? But you can see Alan Jackson. Let me see. Hold on one second. Let me just pull this up. I'm sorry. Sometimes it takes me a minute to find my bookmarks. All right, here we go. Alan Jackson walking away from court. This is Grant Smith Ellis's footage. No sweat. When they said, well, the defense is very quiet and they hung their heads in shame, I didn't see that. They're like, we'll handle this. We'll handle this. No fear. He's like, I don't know what happened. What are they talking about? I don't know what fraud upon the court they're talking about. Duped? I don't know anything about it. He's answering questions like, and once again, if you go back and listen to my interview with David McKenzie, his advice in how to deal with the media is to never say no comment because it makes you look guilty. So he's like, well, I don't know. I don't know what she's referring to, why we have to come back Tuesday. Certainly not anything. It's not my fraudulent behavior that did it. Watch this.
Slow, guys. Nice and slow. Very.
Yeah, so it's very icy, and kudos to Grant for getting this footage. It must not have been fun getting it because it's so cold. I have my heater on. You probably can hear it through my microphone. It is so cold here in this part of the world. I'm in New York. This is closer to Boston.
Be careful, please. Why would the judge have raised concerns about the defense? You don't know what this is? Guys, can we make some room, please? Alan, can you tell us?
I have no idea. Did you just hear him? No idea. I'm not a lawyer. I knew immediately. Hank Brennan just explained it all. I knew immediately what was going on. He doesn't understand the words violations of discovery, dupe, fraud, ghosts, perpetuating a fraud on the court. I'll spell it out for you, Alan. Huh, me? Huh, me?
Dude, what was that 23,000 about, Alan? The sidewalk. We're trying to walk, please.
He's not sure. So this is like when this is like a lawyer trick. Like if you're not sure, you say like, I don't remember, so you don't have to perjure yourself. He's just like, I don't know anything. Is my name even Alan Jackson? Am I even a lawyer? I thought I was playing a part of a lawyer in a TV movie, and I could script my client's testimony, my supposedly independent, unbiased witness's testimony. Thought I could script it. What? I can't? I mean, I'd love to do a poll. Let me do a poll. Hold on one second. I'd love to do a poll for all the people. So just answer this if you were watching this live. Okay? How many of you knew that this was what this was about halfway through or a quarter of the way through or at the end? Any part at this part where if you were walking out of court, would you have known what was going on? How do I hope I can phrase that a little bit better. I don't want to start a Q&A. I'm starting the wrong thing. Instead of a poll, I'm starting a Q&A. Would you, okay, I'm going to do some abbreviations because they don't let you. Would you have been confused by Hank Brennan, R.E. Arca, yesterday? Arca, yesterday. So, I mean, how many of you non-lawyers, yes or no, if you watched it? Just so curious how many non-lawyers got this yesterday. Not. It's not even. And this isn't even our case. We're so removed from it. There he is again. I don't know.
Come on, you're crowded here. Please come on.
He just keeps saying, I don't know. Smiling, I don't know. No hat. Hey, Alan Jackson, maybe wear a hat. I know it messes up your hair, but like Karen Reed never wears a hat. It is so freezing cold here. It's ridiculous. Look how vain Karen Reed is. She can't even wear really an appropriate coat or a hat or scarf. She doesn't want to mess up her hair for her big public court appearance.
Karen, are you and Aiden about to get indicted?
So I was curious. I wonder if Grant was in court or not. But that's what you want to ask about being indicted? Not Alan Jackson. So yeah, that's his. What me? What me worry? And Aiden Carney had some remarks. Let me get to them. Then we'll get into the juror. Hold on one moment, please. Here we go. Okay, so the prosecutor's podcast said somebody's world is collapsing around them, and he's still doing this, and he's saying it's the witnesses. All of them are currently unable to work due to the stench of, he says, murder and corruption that follows them everywhere. No, it's the innocence fraud and harassment campaign. That's why they can't work, Aiden, but okay. Aiden Turtle Boy Carney again. Reminder, it doesn't matter. He's going to remind everybody. Reminder. Let me try to brainwash the public. It doesn't matter who emailed who. That's not the issue. Or how much was paid to house and lodge witnesses. There is nothing but a distraction from the factors. Is that what that $23,000 and $23,900 went to? That is nothing but a distraction from the fact that two doctors, meaning PhDs, said that it was physically impossible for John O'Keefe's injuries to have come from a car crash. Or is he including Marie Russell there? They were hired guns. That's what it means, Aiden. I'll spell it out for you. It means you're a hired gun when you're having Alan Jackson. When you're scripting your testimony with the defense, getting paid big sums to say what they want you to hear. That's why it's disclosed. That's why the number one question to any expert witness is, how much were you paid for this trial? Let's look at our poll. Yeah, almost 80% of people say that they understood what was happening after court. And they're not lawyers, okay? Okay. We're at 70. Okay, I rounded up. Excuse me, 78. 77, now it's going down. Are these all the free Karen readers? Saying Alan Jackson, he just doesn't know as a lawyer. He just didn't know what was going on. Funny. All right, let me pull up the juror on ARCA, and then we'll call it a day.
it seemed like, and everybody, all the witnesses were suggesting that he was never inside the house. And as a direct result, the assumption, or if you connected the dots based on the evidence that was provided to us, it seemed like there was some sort of collision with the car, and therefore there was damages to the vehicle. And with the damages to the vehicle, and that both individuals were there and present, that the cause must have been, or
Right. You didn't think that somehow he magically got in the house with no evidence? That he ever got in the house with none of his data showing that he ever moved from the position he was thrown by Karen Reed clipping him with his car? You didn't think that? You didn't think aliens came down from outer space? It actually would be more believable now with all these drones. But maybe you didn't think something totally improbable it happened?
somehow some sort of involvement by Miss Reed. So that was how they all arrived at.
But how did they reconcile? Was the ARCA testimony brought up by the people that thought that she was not guilty? Did they? I'm sure somebody in that room must have said, but these experts are telling us that that's not possible. And what was the answer to that? Like, did people say that these guys are bullshit artists, that they're fake doctors? Like, what was the reason not to believe them?
I think the major rebuttal was, we don't know. And that was the other thing. It was very ambiguous on why these individuals were testifying. And so there was a question in the group on their essential integrity, in terms of, were they there as a direct result of somebody else trying to steer us in a different direction and confuse the jury. So it wasn't sure if it was insurance. It wasn't sure if it was, whether the Reeds were doing it, somebody else was doing it, or yourself was doing it to bring this group to try to testify so that it would sway the jury in one direction or the other. And that, I think that was one of the things.
Somebody was, I love Turtle Boy's laugh there. Somebody tried to influence him, change. It wasn't that the federal investigation was all directed and ignited by the Reed family. Somebody would change ARCA's testimony? ARCA? Do you hear that little laugh? That independent witness?
That wasn't, again, unfortunate, because I guess it cannot be said, or didn't want to be revealed to us on what were the circumstances of why those individuals were testifying, other than they were testifying for the defense.
Well, luckily, there were two experts provided by the federal government from a company called ARCA that testified, two doctors, and they were the last two witnesses to go. And in order to, they both testified that, according to the physics, the science and the physics, the injuries to John O'Keefe are not consistent with being hit by a car, and the damage to the vehicle is not consistent with hitting a pedestrian. And so those guys are, doctors, PhDs, they do this for a living, etc. And in order to find...
That's a little appeal to authority. Let me just brainwash my audience. Lots of people with degrees can be bought off, be wrong. And we see this all the time in true crime. I was talking about it yesterday. They use this appeal to authority in innocence fraud campaigns. Ex-FBI, detectives, former judges, former prosecutors, not too often former prosecutors, but occasionally. A lot of ex-judges, they'll use in an innocence fraud campaign. This is the most egregious violation of a blah, 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 blah I've ever seen. Let this convicted killer out who's gone through many appeals courts and a jury trial. Let him out. So don't fall for that.
Find Karen Reed guilty of manslaughter, you have to listen to the ARCA experts and say, I don't believe them. So how did 8 jurors reach the conclusion that those guys didn't know what they were talking about?
It was
So, having been a juror last year in a criminal trial, I think it's always very dangerous. I talk about my experience, but my experience of what it was like and what went on in the jury room could be vastly different from another person's experience and impressions. Even though, in my case, it was a essay case of a child who's now a teenager, came in and testified. The first vote was 11-1, of which I was a part of the 11, guilty to 1 not guilty. So it wasn't it was about 2.5 hours of heated discussion trying to convince one juror. No, maybe about an hour and a half, 2 hours of heated discussion, of which I didn't. I didn't do much I just expressed how I felt. I wasn't going to try to. I let other jurors do it because I knew I was way too triggered. Lazy Susan says Hank should have asked for metadata on the emails. That's so funny. So that's one of the things they argued yesterday, was that they need the metadata of the video, of this video from the Sally Port that they're trying to get, that they just asked for the first time in 3 years, and they're up in arms about. They were making a big deal about that in the first part, right? And Hank's like, metadata, schmetadata. I'll get you the video. You want the video or don't you?
Direct result of Karen was there at that time.
Oh, wait. Sorry. Did I go back? Oh, okay. Sorry.
At that location. And therefore, it seemed like, and everybody, all the witnesses were suggesting that he was never inside the house. And as a direct result, the assumption, or if you connected the dots based on the evidence that was provided to us, it seemed like there was some sort of collision with the car, and therefore there was damages to the vehicle. And with the damages to the vehicle, and that both individuals were there and present, that the cause must have been, or somehow, some sort of involvement by Miss Reed.
So there you go. There you go. We thought it was. Someone thought that they were paid. Here's another. Hold on. I'm gonna take another quick break. When I get back, maybe we'll talk a little bit more about this juror. Don't go anywhere. I'll be back in 1 minute. Whoop. Meet you on the other side of the break, guys.
We gonna take a break. Grab a snack or maybe a glass of wine. Roberta will be back in no time. This podcast is listener supported, so smash that like button and subscribe, or become a patron for exclusive content if you are so inclined. Have something to say. She'll revert a super chat. She will do her best to read it all air without delay. Now Roberta's back and ready to put the true back in true crime. Here's Roberta.
All right. So one more comment. This is, and thank you, Innocence Fraud Watch, for these clips. So he's like, now you know that they were all independent. How foolish of you for thinking that they weren't independent. Check out this clip from Aiden and the juror Ronnie, the EMT.
I guess it cannot be said or didn't want to be revealed to us on what were the circumstances of why those individuals were testifying, other than they were testifying for the defense.
Because now you know, obviously now that the trial's over, that they're not even defense experts, they're FBI. They were available to both sides, and only the defense called them. But it seems like the conversation in the room went, and they said, some people were suggesting maybe they were the insurance company, of course, because of course an insurance company would benefit from not having an automobile collision. Obviously, they wouldn't have to pay anything out.
Right. So Aiden repeating again what Alan Jackson said in court. You were available to both sides, but they only said what the defense wanted them to say. Isn't that curious? And we know from the emails, just, if you don't want me to say that, I won't say that. But here they are. Oh, the prosecution could have used them. They had $23,900.
Or me? How did people thought I paid the ARCA guys? That's wild.
Like anybody, somebody was trying to, again, to try to...
Oh, the stupid juror. The stupid juror thought that somebody was paying, maybe Aiden Carney, that they were so out to lunch with their opinion that someone had to be paying them. Oh, how stupid. We don't know. He's like, I'm not that stupid juror. Wonder how he feels now. That's what Innocence Fraud Watch is asking. Her tweet.
Sway the jury in one direction versus the other.
All right, I just wanted to highlight that. Unreal. Must feel pretty stupid now, huh? Let's see where we're at on our poll. We're at about 80-20. Up. Anybody last? I'm going to end it. Anybody else want to vote before we end? All right. So it wasn't hard to understand. I didn't think. I think a lot of my audience are really experienced trial watchers, know how the system works. So that's what I have for today. I think we've done it, guys. I'll be back tomorrow at 6 p.m. Eastern. Thank you, Maestro, for moderating and doing such a good job. I appreciate it. And I appreciate you all for listening. Going to end out the way I always do with my song. Hit my boyfriend with my car. Have a great night, everybody.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence from drugs and witness harassment. I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system, my clown.